Hi everyone, I'm Dan Kaplan from SC Magazine. I'm at Black Hat 2012 in Las Vegas, and beside me is Marcia Hoffman, Senior Staff Attorney at the Electronic Frontier Foundation and Internet Civil Liberties Group. Marcia, thanks for joining us.
Thanks for having me. I appreciate it.
Now obviously you guys are quite busy at this show, and a lot of people may not know that EFF plays a significant role at the Black Hats, the B-Sides, and the DEF CONs of the world, because you have a lot of researchers delivering talks which may not necessarily some of the vendors that are talking about may not necessarily love that idea. So tell me a little bit about your guys' role here.
Sure. The Electronic Frontier Foundation has a project that we call the Coders' Rights Project. It's been around for about 4 years, and we spend a lot of time speaking with security researchers who are pushing the boundaries and doing really amazing cutting-edge work, and helping them navigate the often murky legal situation around the research they're doing. And as an outgrowth of that, we spend a lot of time talking to them about talks that they plan to present at conferences like this one. We like to try to get looped in early to help them design their research in a way that keeps them as legally safe as possible, and to help them make sure that their talks are not likely to result in a lawsuit that might come down the pipe to try to make them stop their talk, or be filed in retribution for some of the research they've done.
Mm-hmm. So take me through the average road of a researcher who wants to deliver a talk at a Black Hat or a DEF CON or the like. They have an idea. Where do they go from there when it comes to navigating some of the murkier legal waters, as you talk about?
Right. Well, ideally, I would like them to come to us early so that we can talk about ways that they can conduct their research that are likely to be more safe than other ways they might choose to conduct their research. And I think a lot of security researchers don't have a very good handle on the various laws that might come into play. For example, in the United States, we might be dealing with the Wiretap Act if it's security research that involves, say, mobile security. Right. We might be dealing with the Digital Millennium Copyright Act, which penalizes circumvention of DRM and other technological protection measures that protect copyrighted works. We could be talking about some of the computer intrusion statutes, like the Computer Fraud and Abuse Act, and we're in a good position to help issue spot for the researcher and help them kind of think through ways that they might be able to do their research that wouldn't implicate those laws so much, or might avoid breaking those laws. Yeah. So that's the ideal thing to begin with.
So what is a general rule or recommendation for a researcher who wants to tinker around with a product and wants to find a way to exploit it? I mean, should they notify the vendor? Do they notify law enforcement that they're doing? I mean, how does it work?
Well, what typically happens is they notice a vulnerability, and then ideally they will go to the vendor to discuss that and let them know about it, and ideally also give the vendor enough time to fix the problem before going public with the information. And exactly how much time, I think, is very much dependent on the situation. And there have been circumstances in the past where speaking to a vendor in advance basically gets you slapped with a lawsuit to try to prevent you from speaking about it publicly. And so, I think it's important to take into account the circumstances and try to figure out how to avoid that kind of a result, and make sure that the researcher is able to do the research, ideally get credit for the research, and present it, but also ensure that users aren't put at risk, and that vendors have enough time to fix any problems that are reported.
Yeah. So there may be times where the vendor is doing the responsible, or the researcher, I should say, is doing the responsible thing, going to the vendor, and the vendor says, "Thanks for telling us, but no, you're not presenting this."
Well, and that can happen. There are also situations where the researcher informs the vendor, and the vendor says, "Thank you very much," and then the problem never gets fixed. And then, that puts a researcher in a really tough position. Do I talk about this publicly because public pressure might actually help to encourage the vendor to finally fix it? Or do I just, be quiet about it because it might put users at risk or harm the vendor in some way if I go public with it myself? And so that can be a very tricky situation to navigate.
Are you required to tell the vendor at all and give them an opportunity to fix it, or is that a kind of an it depends situation?
Well, there's no legal requirement that you do that, but I think there are very major ethical considerations there. And so, basically I think a researcher has to weigh the circumstances and consider the situation and decide what he or she feels is most appropriate.
Yep. So what is your role to show? You're meeting with some of these researchers on a pro bono basis, so that's for free.
Right.
And they can come to you with questions, and you can inform them of the laws and their free speech rights and those sort of things.
Right. we're happy to talk to folks about any legal concerns that they have. Our expertise is obviously in a certain area, which involves privacy laws and copyright laws and computer intrusion laws. And we try to help where we can. If we're not able, because we just don't have the expertise or what have you, then we do what we can to make sure that the researcher is able to talk to a lawyer who can help them out.
Mm-hmm. Now, you can't get into specifics, of course. There have been some past cases that you guys have come in and represented some of these researchers. What is the risk? Is the risk lawsuit? Is the risk possible arrests, jail time, that sort of thing?
Depending on what laws are involved, those are all possibilities. I think one of the big risks is that a researcher makes a vendor so mad that the vendor files a lawsuit, a civil lawsuit. But some of these laws also have criminal penalties, which means that the government could prosecute if it sees fit.
Yeah.
So there can be some pretty serious considerations when a researcher is thinking about how to present this kind of research and go public with it.
And now Black Hat's in its 15th year. DEF CON's been going on for a long time. Obviously, these vendors are realizing that security research is reaching levels that it never has reached before. Are they starting to be more okay with people fiddling around with their products?
Well, I think it depends on the company. There are some companies that are very receptive to hearing about reports of vulnerabilities from outside researchers, and they make clear on their websites, if you have a problem, this is how you get in touch with us. Some of them offer bug bounties, where basically they will pay researchers for disclosing certain bugs, and so those are steps that some companies take to be to encourage researchers to be more forthcoming. But then other companies don't react well at all, and some of them have never had an experience having a vulnerability reported, and when they hear about this for the first time, I think, not surprisingly, that can be a very daunting situation for a company to find itself in.
Sure. And have there been experiences in the past where talks have been pulled, or there's been obviously threatened litigation?
Well, I can tell you about one example at DEF CON a few years ago, where 3 MIT students planned to give a talk about some vulnerabilities they found in the Boston T's fare system. The Boston T is the subway there. And the MBTA, the Massachusetts Bay Transportation Authority, got really upset about it and sought a temporary restraining order to keep them from giving the talk. And unfortunately was successful in making them cancel their talk. And we represented the students in that case.
What was the windup?
Well, ultimately, they won their case. The judge found that they hadn't, that the restraining order should be lifted because it didn't appear they'd violated any laws. And so at that point, we reached a settlement with the MBTA, and the students helped them to fix the vulnerabilities they discovered.
And the EFF, of course, is available year-round because there's research going on year-round.
Absolutely.
What is the best advice for researchers? Should they contact you guys?
Absolutely.
Yeah.
If researchers ever have any questions about their work, we are always happy to talk with them. And they should just contact us at info@eff.org.
Marcia Hoffman, Senior Staff Attorney at the Electronic Frontier Foundation. Thank you for joining us.
Thank you for having me.
And good luck at Black Hat, DEF CON, and B-Sides.
Thank you.